Law Weekly, we talk to a prominent commercial legal practitioner, Mr. Kemi Balogun. He gives yet another perspective for tackling the cumbersome delays associated with court proceedings. We also track the developments with the Southwest Lawyers Forum, Egbe Amofin, in its quest to produce an acceptable candidate for the elections of the Nigerian Bar Association scheduled for July this year. That is the lineup. I am Shola Sheyeli. Let's quickly bring you up to speed with the top stories that happened in the courts this week.
We begin at the Federal High Court in Abuja, which last week Monday ordered members of the House of Representatives to refrain from changing or taking steps to change the leadership of the legislative body, pending the determination of a suit filed by the People's Democratic Party. In the pending suit, the PDP is asking for an order of perpetual injunction restraining the House of Representatives. Its Speaker, Aminu Tambuwal, Deputy Speaker, Emeka Ihedioha, and 49 others, including the 37 lawmakers that defected to the All Progressives Congress, from changing or altering the leadership of the House. The court, presided over by Justice Adeni Ademola, ordered the lawmakers to maintain status quo pending the final determination of the case. Hearing was then fixed for February the 3rd. In yet another case, the People's Democratic Party has asked the Federal High Court in Abuja to decline jurisdiction over the suit filed by some members of the National Assembly, seeking to restrain it from declaring vacant the seats of some of its former members who defected to the All Progressives Congress.
The piece of evidence we are next.
The party's prayer was contained in the preliminary objection it's jointly filed with its former chairman Bamanga Tuka against the suit instituted by 22 PDP senators and 57 members of the House of Representatives, including those who have defected to APC. The party and its ex-chairman urged the court to dismiss the suit on the grounds that the plaintiffs lacked that requisite legal standing to institute and sustain this suit, that the suit amounts to an abuse of court process, that it was wrongly commenced, and that there is no reasonable course of action that lies against the defendants. Staying with politics, the Supreme Court during the week again affirmed the election of Rochas Okorocha as the governor of Imo State. Justice Clara Ogunbiyi, who delivered the judgment, criticized former Governor Ikedio Hakim for embarking on an endless litigation after he was joined in the appeal instituted by a former governorship candidate, Senator Ifeanyi Ararume. The court held that the application for joinder granted by the Court of Appeal is an attempt by Mr. Hakim to challenge the election of Mr. Okorocha through the back door, long after the case had been settled by a properly constituted election tribunal. Another governor in the news is the governor of Lagos State, Babatunde Fashola. The Socio-Economic Rights and Accountability Project has sued him for allegedly failing to release information and documents relating to government spending on certain projects in the education sector. The group wants the court to compel the governor to release to it information relating to how the government spent the $90 million loan allegedly obtained from the World Bank to improve education in the state's public secondary schools. It also seeks an order of mandamus compelling the governor to rescind the suspension of anyone, including principals of any of the schools, for blowing the whistle or allowing journalists to cover the decayed infrastructure across primary and secondary schools in Lagos State. The matter is yet to be assigned to a judge for hearing. We round off in India, where the Supreme Court there ordered a judge to investigate the gang rape of a tribal woman, a rape allegedly carried out on the orders of village elders who objected to her relationship with a man. Describing the case as disturbing, the court ordered the district judge of Birbhum in West Bengal State to visit the village and submit a report. 10 men, including the village headman, have been arrested. The 20-year-old woman is in hospital. Her condition is reported to be stable. Scrutiny of sexual violence in India has grown since the 2012 gang rape and murder of a student on a Delhi bus.
Welcome back. My guest is best known for his work as an insolvency practitioner. He's an authority on corporate commercial law and renders legal opinion to banks, multinationals, and governments. He is also a chartered arbitrator and a consultant to the Ekiti State Government. In this interview, Mr. Kemi Balogun shares his perspective on the performance of the judiciary and also gives suggestions for tackling the delay associated with court proceedings. Let me start by getting your assessment of how well you think that the judiciary fared in 2013. I've had lawyers say to me that the judiciary's performance was below average, and I've had other lawyers who said that it was reasonably fair, especially when you consider discipline, the CJN and the reforms that she tried to bring in and all of that. But looking back, how well would you say that our judiciary performed in 2013?
To assess 2013, you need to take a look at how things were before 2013. You had a judiciary that was demoralized by integrity deficit. You had a judiciary that had suffered loss of confidence. You had a judiciary that had suffered loss of integrity. You had a judiciary that, even in the public domain, people just believe that nothing good could come from the judiciary. Now, then came 2013. Don't forget that it was in 2013 that you have what anybody will refer to as some level of cleansing. Cleansing in the sense that you had, for the first time, somebody is able to take the bull by the horns. And what do you have? You have two judges. You know them. You also have some senior counsel, discipline. You also had
one other judge that was suspended. Now, you may be aware that it is no longer possible for anybody, even in the higher court, to rise through the ranks without having reaching any lead judgment. So in other words, every judge now is made to report and file returns with NJC of his productivity. I think to say that is a below average performance, I think that will not be a fair statement, and it will not be a fair assessment. I do not agree with that view. But in saying that it was a below average performance, I think consideration was given more to the fact that a lot of people still have issues of delay. We always say that the wheels of justice grind slowly. It's become almost cliche. And so the length of time that cases go through the ranks in courts, almost endlessly. At least Odisa Agbakova said to me that they review their cases and they find that a case from start to finish, that's from the trial stage to the appeal processes, maybe 12, 13 years at the most. And so it's that issue of delay that a lot of people are still worried about. What do you think that we can do to combat that challenge?
It's a two-edged sword, in the sense that what are the causes of delay? Who are responsible? Who and who are those responsible? Number one, the court, the lawyers, and indeed all stakeholders in the justice delivery system. Now, if you have a court that understands, that knows its onions, the judge has read through his file before coming to court. He knows exactly the business of the day, and then he goes straight. He doesn't waste time. He knows the onions, he knows the rules. He will not. Lawyers know. Lawyers, they know the judges that will not allow you to waste his or her time. They know the one that they can mesmerize around. So leave that. That is for the court. But for lawyers, I think it's more about reforming the rules. I remember in Amadi and NNPC, Justice Ruiz lamented that it took 13 years for the matter to rise through the ranks from the High Court to Supreme Court, and lamented about the delay. Guess what? On interlocutory issue.
So So they didn't even touch this
on interlocutory issue. You have a lot of rules in place that encourage delay. For example, there's a rule that says every application, no matter how stupid, no matter how frivolous, must be taken by the court. So, if you are a lawyer who wants to waste the time of the court, all you need to do is for you to file it, particularly if it suits, depending on the game that you are playing. Then you file it and you take it all the way. Guess what? Even in some cases where the law is settled and replete, particularly on jurisdiction, counsel have been known to file and they take it up.
Because the rules allow it.
Because the rules allows it. And then they take it up all the way to Supreme Court for even on a matter that is settled law. Sometimes it borders on professional misconduct, because where you have a viral bar, where you have a viral disciplinary committee, I think it borders on misconduct. Particularly where the law is so settled, then you take it all the way only for you to get to the Supreme Court, and the Supreme Court then award something like 50,000 naira damages, and then you cost, and then you wonder who is being, what would